Hi, I'm Patricia.
Gabby. I'm Nicole.
I'm Javier.
And we will be discussing the Sixth Amendment and how a trial can become too public. How can the rights of the accused guarantee the Sixth Amendment be balanced with the First Amendment right of the public to know? And to what extent does pre-trial publicity prejudice potential jurors and deny defendants the right to a fair trial? And what important purposes do public trials serve? So I'll start. As part of American obligation and tradition, American citizens, to the most extent, are obliged to take part in public juries. In the Bill of Rights, the Sixth Amendment states that in all criminal prosecutions, the accused shall have the right to a speedy and public trial issued by an impartial jury. All judges must be well informed of the nature and cause of the accusation, and the accused must have fair access to a defendant. However, in some cases, the right to a public trial can be taken too far. There have been instances that have ruthlessly showcased the trials of public figures, celebrities, and other important people on all platforms of social media. This can cause for an outrage of bias and subjective judgments from people who are potentially ill-informed of the issue, and therefore causes an influx of problems that would not arise if the trial hadn't become too public. Every person that takes part in a jury still has the same rights as any other citizen. However, the respect for the accused is becoming increasingly diminished as social media coverage embellishes stories and makes them worse than they actually are. In order to balance the rights of the Sixth Amendment for the accused and the First Amendment for the public, juries should implement laws that give the rights of the accused to choose whether or not they offer a public jury. While most would agree to a public jury, there are some exceptions with celebrities and public figures. If the public is adamant about attending a particular public jury, the government can send them to a similar case later on. Overall, the rights of the accused are not a priority, and having unnecessary disturbances can cause for an inaccurate and biased jurisdiction.
In court cases in the past, the extensive media coverage and public involvement has casted a bias in the case in other aspects of society. A good example of this is the People versus O.J. Simpson trial. Because this trial was heavily publicized, everyone in the nation formed their own opinion about the trial. By the end of the trial, surveys showed large discrepancies between white and black opinions on the case. Many say that this trial refueled the never-ending feud between Caucasian Americans and African Americans. If the trial had been more concealed to the public, the ongoing battle between white and black lives may not be as severe as it is today. Although by definition a trial must be public, the extent of how public it is debatable. Some say having widespread media coverage of trials is important because these trials display history being made. But the public has the right to know as stated in the First Amendment. But extreme media coverage can cause bias and corrupt activity in favor for the rich and famous. This topic is very controversial, but in the end, all trials must have a balance between both public yet concealed.
Cases with a lot of media coverage often brings up the issue of having a fair jury. Due to extensive media coverage, jurors can develop a bias on the case. During voir dire, jurors are assessed for their impartiality. Defense attorneys and the prosecution attorneys question the jurors to assess their impartiality. Exposure to previous media influences have a large impact on the jurors because it causes them to create a bias even before the trial has begun. In order to make the trial as fair as possible, jurors are able to be eliminated by a lawyer. If defense attorney and prosecution attorneys make a mistake and let a biased juror onto the trial, then the defendant has not had the right to a fair trial. Media coverage of the issue amongst jurors poses as a large threat because one never knows the extent of the issue. The jury has already, and whether they have formed a bias yet.
Capital cases in particular often attract extensive emotional charged coverage. These cases also present greater difficulties than other cases because death-qualified jurors may be more susceptible to pretrial publicity than other jurors. According to a 2007 study, participants who passed a simulated death qualification process were more likely to recognize the facts of a highly publicized murder case and were significantly more likely than excludable jurors to think the defendant was guilty and that he or she should be sentenced to death. Researchers found two likely causes for these findings. First, death-qualified participants were more likely to watch daily news programs, making them more aware of the facts in the case. And second, death-qualified jurors in other studies have shown pro-prosecution beliefs, making them more inclined to find the defendant guilty.
According to Sir Edward Coke, a trial is already by definition open to the public. In the established course of the common law, all trials are in open court and onlookers are invited. Public trials are necessary to safeguard against the abuse of government power and restore idea of dignity, order, and justice. Public trials increase awareness on the results of abusing state power in bigger countries. The founders of our nations understand the danger of preventing public trials because they lived under tyranny and experienced the results of not having such trials. At these trials, citizens can form opinions on, to, or against the convicted and first-handedly experience justice being served. The idea of open justice in the Sixth Amendment gives citizens a feeling that they're included in the process and have weight in the decision. In reality, however, impaneling of the jury and the verdict, as well as certain pre-trial proceedings, show how all stages and phases of criminal prosecutions do not have to be open to the public. In their defense, judges close parts of the trial for citizens' privacy protection, which is necessary to preserve the confidentiality of sensitive information like the identity of undercover witnesses.
Thank you. You guys definitely went over a minute, but that's okay. Questions for the group? Robin?
What's a death qualified?
It's death qualified jury is a jury in a criminal law case in the U.S. in which the death penalty is a prospective sentence.
You mentioned the study from 2007. Who actually conducted that study?
Butler.
Who the hell is Butler? Okay. This goes for everyone. What are some positives to a public trial?
Like Patricia said, like the judge can get more feedback, and it's not totally based on like the government power. And the citizens also have a right to express what they feel. So it's just
Citizens
more
feel like they're
participation.
And like they're kept up on like important milestones that happen in history that like are currently happening. Because if they didn't know about it, then like I felt like everyone would be in the dark.
Any other positives to a public trial? Do you think public trials might keep those involved accountable?
Yeah.
Would that be a positive?
No. I don't think so. Depends on who actually did it. It's not good to bias the public and reinforce their false opinion on like who did it or who did it.
What about the prosecutors and the defendants, keeping them accountable? What are some negatives to a public trial?
Like for celebrities and public figures, extensive social media coverage, and sometimes in the O.J. Simpson trial, it just caused a lot of discrepancies between like whites and blacks and other. It's just when it goes on social media, it just embellishes the story to the point where it doesn't need to be out there. And it like kind of makes it false in some parts.
Yeah, if you guys watch The People versus OJ, that court case, some people actually thought that it was a show and not an actual trial. Like, that's how bad it got. And the trial was for 8 months.
And it caused like just a lot of unnecessary like hatred between people like, with different views and things. And I think it's still like carrying over today. And if it wasn't so public, then we wouldn't have this many problems.
So in your guys' opinion, should trials be more private or public?
I mentioned that it's in certain cases, like if you're a celebrity and you don't want your name and what you've done to be showcased on social media, then you can have your own right to not have a public trial. But if you're just a citizen, a normal citizen, then you should be held accountable for what you're doing, and you should have a public trial. So it just depends on the case itself.
What about the rest of you?
I feel like it depends on the way that the media portrays these trials. So if they're going to go all out and like with the O.J. Simpson trial, then I think it's best not to. But if they hold back and just merely inform the public that this trial is going on, then I think it's fine. So I think it's the way how the media portrays the trial rather than the people themselves.
So rather than have cameras in the courtroom, maybe you can have a reporter. Okay.